We're down because
And welcome back to Law&Crime. I'm your host for the afternoon, Caroline Polisi, and we are full of special segments for you today. Of course, we are analyzing the verdict that came down late last night in the Todd Kent Hammer case. He was found guilty of murdering his wife, Barbara Kent Hammer. Of course, the story he told jurors was that this was a freak accident. A pipe came through the windshield of his car while he was driving his wife, Barb, and it was a freak accident. The jury not buying it, you guys, not buying one bit of it, finding him guilty on this count. He will now have to face the consequences. I'm joined today with very special guest, criminal defense attorney Saam Zangeneh. Saam, thank you so much for being here with us.
Well, thank you for having me.
Yeah, and so Saam, you are a former state attorney in Miami. You're joining us over Skype, and you've got some thoughts. We were talking previously off camera. You've got some thoughts about this verdict. Why don't you let us know right now?
Sure. So I think that Mr. Kent Hammer him and his team made a critical mistake when he chose to testify and take the stand. I got to tell you, I couldn't figure out what his defense team was thinking doing that, because it appeared to be a battle of the experts. Okay, both sides, the government had their medical examiner, they had their expert testimony, and the defense team had expert testimony with regards to several experts that came forward and pretty much attempted to bolster his defense. So putting him on the stand was a lose-lose situation, and worse than that, he got caught up in a lie. And not only did he get caught up in a lie, when he got on the stand and he got caught in that lie, he then changed his story, which the government on rebuttal came back and showed that his second story was also a lie. So what does that make him?
A liar.
A liar. That's it. And so when you have expert testimony, it should be battle of the experts. Let me tell you, 2 years ago, I did the Facebook killer case. And it gained national attention. It's a gentleman who killed his wife and took a photograph right after he killed her and he put it on Facebook. And so it wasn't a whodunit, it was an affirmative defense case.
Right.
And so what was critical in our case, we had a forensic examiner to rebut the government's forensic examiner. And who did we hire? Michael Bogman. You have to get the cream of the crop.
Yeah.
And so, it looks like they made two critical errors there. They did, in my estimation, their experts weren't to the level that they should have been, and then they put them on the stand.
Right. I mean,
obviously, right?
Yeah. To your point about the experts, we saw some of those defense experts really becoming prosecution witnesses as they got on the stand. I think all of us, we were shocked at sort of the admissions that some of these, quote, defense experts were making on the stand, really giving more weight to the prosecution's theory of this case. I want to zone in more on this issue of putting a defendant on the stand. We're both criminal defense attorneys. We know that we can make a lot of strategic calls in terms of what witnesses we call shaping a case, but the ultimate decision about whether or not a client testifies is going to get on that stand, that's the client's, right? How do you deal with clients that want to get on the stand?
No, listen, it's up to the client, but let's be honest. We influence them to the nth degree.
Yep.
Unless Rihanna or Beyonce as a client that everybody's going to love, it's going to have to take a unbelievably compelling situation to understand, because then look what happened in this case. I mean, he had a weird crackpot theory of this freak accident with sub-player experts, but they deliberated for almost 9 hours, which means they were talking about this. It wasn't like they went in there for 2 hours, they found him guilty, and they came back. They were actually talking. So putting somebody on the stand, you run the risk of them making that one hiccup. And Ken Hammer here not only made one hiccup, he had like a slew of hiccups.
So how do you prepare Kent Hammer for this testimony? I mean, do you think that his attorneys could have sort of immunized him from this exact issue that happened just through sort of practice getting on the stand prior?
Let me tell you what we do. In my firm, with my mock cross-examinations, and we bring in experts, guys that are just going to drill and drill and drill. And after 2 minutes of getting drilled by someone that we bring in, we look at them and we're like, you got murdered.
Yep.
Unless they do fantastic against a cream of the crop criminal defense attorney in a mock cross, they're not going to get on the stand, and we let them know how bad they look. So it's one of those situations where if you can you could try to prepare these guys, but the reality is, unless it is a must-have, which it wasn't in this case, you shouldn't put your client on the stand. It's a recipe for disaster.
Okay, so we both know that it's sort of defense attorney 101, never put your client on the stand. However, we know that juries like to hear from the defendant. They see him or her sitting there throughout the duration of the trial during the prosecution's case, and it's just human nature. They want to hear from that person's own voice, his own recantation of the events that occurred that day. Is there ever a scenario in your time as a prosecutor? Oh, can you hear me, Saam? Sorry, we still out of connection? Okay, guys, I'm sorry. I think we may be having some technical difficulty with Saam. Did we get you back, Saam? Okay, you know what? We're gonna take you back now to that closing argument in the Todd Kent Hammer case. We're gonna see if we can fix some of our technical issues here, and hopefully we'll be back soon with Saam.
Beautiful day. We know from everybody else it was not a beautiful day. It was overcast and raining. He turns onto the road. He tells you he goes by, and he doesn't see anything. He doesn't see damage to the windshield, and he doesn't see Todd. And I agree, he didn't see. That he doesn't see the windshield doesn't mean that the windshield hadn't been penetrated. He just didn't see it. And Mr. Meshlam told you the extent to which he went through to determine what angles he could view it from, where the sun was in the sky, and what it might appear to someone if they passed by. Now, Randy Erler sees a car in the ditch. He told you the door was open. He didn't stop. He was late for work. Tells you he just rode by it. So in the space of 1 second, shall we give him 2? He goes by and he tells you what he didn't see, which does not prove what there was. Now, it's the state's theory. If you look at this, the first 911 call is at 8:05 and 23 seconds, and that's by the 911 clock. So we're looking at about a 5-minute interval between turning onto the road and 911 being called. And it's the state's theory, at least as far as I can glean because it's never been specific about it, that somehow Mr. Kendhammer, for a reason unknown to anyone in the world, starts beating on his wife in the car, turns onto Bergen Coulee Road, puts the car in the ditch intentionally, gets out of the car, and pulls and drags and forces his conscious wife, because it's the state's theory that she had not yet received that blow that rendered her unable to control her motor function, that he pulls her out of the car and beats her, producing no defensive wounds whatsoever. And then, when he's sufficiently beaten her, goes into his trunk and takes a pipe which he thought about taking ahead of time.
Welcome back to Law and Crime. Sorry if we had some technical difficulty on our end with our special guest today, Saam Zangeneh. Saam, thank you for bearing with us and for being back here with your analysis of the Todd Kent Hammer trial. We were just getting into some of the nitty-gritty about putting your client on the stand, and I wanted to know if in all your years of practice as a criminal defense attorney, you have ever chosen to put a client on the stand.
I did once in federal court. It was a drug allegation out of Puerto Rico, and my client was the girlfriend slash mother of the main target, and so she was in the house when he was arrested, and they kind of tried to bring her in the case. But listen, let me tell you, she was gorgeous and she was charming, and throughout the trial we saw that the jury was warming up to her. They would smile at her when she walked in. You could feel the vibe, and so we felt comfortable, and she was sharp as a tack, and her defense was simple. There was no, it was a very simple, I'm innocent, I'm being brought into this collaterally. So it was a simple defense, and I got to tell you, she did good on the stand, but we were worried.
Yeah.
We were worried.
Even then you are worried, right? I
Absolutely.
will say that, the prosecution's cross of Kendhammer was extremely effective, and that's kind of your textbook breaking a witness from the prosecution's standpoint. They hammered home. They were rapid fire with the questions, and as you said, they caught him in a lie. How does that play to the jury?
I mean, it can't play well, right? I mean, here's the reality. That jurors are very observant, okay? And if you put your client on the stand like they did in the Kendhammer case, they're not going to remember certain things. And here's what shocks me. He gave a statement. He gave a statement already to law enforcement the night of the incident. So they had his recount of what happened. And so knowing that, they put him on the stand, knowing his story was going to change.
Right.
I mean, and you're right. The prosecutor filleted him like Salt Bae does to a steak.
Yeah.
I mean, it was hard to watch from a defense standpoint. But as a former prosecutor, I was very impressed with the work that this guy did.
I was as well. I was very impressed. I will say my heart sort of went out to Todd because I think he realized he was in over his head once he had made that decision. But again, can't unring that bell. Do you think that was the fatal flaw in the defense's case, or do you think that had he not gotten on the stand, we would have seen the same verdict nonetheless?
You never know. You never know. Cases, as you know as a defense attorney, cases like change at the drop of a dime. Things could be going swimmingly, and then all of a sudden something happens that changes the perception of the case. And so, I got to tell you, I don't think it was a slam dunk conviction until he took the stand. He had a crackpot theory, let's be honest. This, the pipe coming through, and this guy was a former glass maintenance guy or something, glass mechanic. So it was all these odd kind of, circumstantial things that make you go,
Right.
And so until then, I wasn't sure which way it was going to cut. And then he got on the stand, and, he put the noose around his own neck.
Yeah, I sort of agree with you, Sam. I think that this is a case, a lot of cases that we follow here on the network at Law and Crime are clear slam dunks. The anchors are sort of in line with sort of our chat room watchers and sort of the public at large with how they think that a case is going to go. I've always said I love a conviction prediction here, so I always like to ask my guests when I have them on prior to the jury determination. I always ask them to give a prediction, and usually it's pretty clear what's going to happen. I will say that I, for one, felt like this was a case where I think he probably did it, but I would not have voted to convict. I think that there was room for reasonable doubt before he took the stand. From my perspective, it was the issue that really, kept me up at night was where were they going? The issue of his story changing 3 times, where he was going, why he's the one that called Barb's mom that morning to say that he had some workers coming in when it was usually Barb that made the call, which I thought was an excellent point made by the prosecutor. And the fact that Barb had not called in late to work that day, and they were in fact driving in the opposite direction of her place of work at the time that the alleged accident occurred. That, to me, was sort of the nail in the coffin. But had it just been, as you said, a battle of the experts, I think that this case could have left some room for reasonable doubt. I think that he had a shot of getting away with it. Unfortunately, he made the decision ultimately to get on the stand and speak in his own defense. And I think he drilled the nails in his own coffin there. When you have a case like this, a case that's not a whodunit, right? The issue of who perpetrated the crime isn't at issue. How important is it to go into the background of the defendant and really look to any priors that he may have had? Because that's one of the things that, again, kept me up at night. This guy, by all accounts, was a model husband. He testified that he didn't even raise his voice once throughout the duration of their years-long marriage. So that's pretty unusual when you have a crime of this level of violence. What, you're shaking your head?
Well, listen, let me tell you. In any domestic, when a spouse or when a husband or a wife dies, and it's under unusual circumstances or suspicious circumstances, who's always the first person that they think did it? The spouse.
Right.
So listen, you're married. That's motive. Listen. He could have gone 25 years without raising his voice and then flipped that one day. He wanted to take the stand to show that there was no motive. Guy, you're married. You're married. Marriages, people explode at any minute. So terrible strategic decision, because he could have put on other family members, their children could have testified, and I believe they did testify on behalf of their father, and they said great marriage, no violence. That's all they needed to put him on the stand to try to solidify or buttress the other family members' account of the fact that he was a model citizen. Who cares? Big mistake, because you've already got that out there.
Right.
And so it's always easy to Monday morning quarterback, and I'm sure that his defense team struggled with the option. I don't know if they advised him against it, but one has to think, it's probably the decision that's going to haunt him for the rest of his life in custody.
Yeah, but don't you think that the testimony, Todd's testimony, that in fact he never once raised his voice to his wife, that in some sense sort of undercuts his credibility? Because I think as a married person myself, I think we all know that, throughout the duration of a years-long marriage, there are, of course, going to be times when you raise your voice to your spouse. So it's an incredible statement in the literal sense that he has never raised his voice to his wife. Therefore, what more is this guy lying about?
I mean, listen, he got caught in a factual lie. So any opinion positions that he gives are going to be considered marred. Listen, you lied about where you were going twice. So the fact that he says he didn't even raise his voice to his wife, I think that's going to roll off their shoulders once the fact that, all these other pieces of information came out. I mean, let me tell you, he really kind of sunk his own ship.
Yeah. I want to talk a little bit more about the experts, because I got mired down in the details of the expert testimony in this case. There was blood on both ends of the pipe, whether or not where actually blood was found. At one point, I was shocked to hear that there was when the forensic examiners received the car, the seatbelt was not engaged. However, when they pulled it down, there was blood over the band there. I mean, there were some very interesting pieces of information. Of course, we heard from an expert in glass analysis, which I thought was riveting. Do you think that any of that testimony played a part in the jury's decision, or do you think that they were going 100% based on sort of the credibility analysis of Mr. Kent Hammer?
You know what? I think up until the time that he was testifying, or that he chose to testify, I think the jurors in their mind were making that tactical decision as to whether or not the government's experts were convincing enough to trump the defense experts. And remember, listen, this is a criminal case. The standard is beyond a reasonable doubt. It's not civil. It's not a preponderance of the evidence. So they must have believed the government's experts to the nth degree and completely discredited the defense.
Right. Because, I'm having a little difficulty seeing you, Saam. I think we're going to throw back to a clip now. We're gonna hear a little bit more of the defense's closing argument in the Todd Kent Hammer case. Again, he was found guilty of murder. His wife, Barbara Kent Hammer, he now awaits the penalty phase of his trial.
Bashes it into the window, and being unsuccessful, bashes it through, and pulls it out, somehow getting blood on particles of glass outside the windshield when she hasn't bled enough yet to do that. And he does it all in a public place before Mr. Erler passes by, right? Because the significance to them of Mr. Erler in his not having noticed the damage to the windshield is it hadn't occurred yet. So what does that give him? 2 minutes to think of all of that and do all of that. And that's absurd. This is from the second 911 call that he makes. Says, and he's screaming here, I'm sorry the audio didn't work as we planned. How long, get her off the road. Should I get her next to the road? I'm going to try to do something with her. I'm going to put the phone down. I'm sorry it didn't play. I wanted to remind you of that which you probably don't need to be reminded of, and that was his tone of voice. That was a tone of voice of a truly distressed person, not somebody who was making this up as the state would wish you to believe. How long? He says, I'm going to try to do something with her, and he does what he told you he did, because her head was facing down by the wheel of the car after they fell out together. They fall out together. He's giving her CPR. On those calls, the state is telling you he's not giving her CPR. On those calls, you can clearly hear as he is pumping because she had stopped breathing. And so he moves her from where she was. Now, the state, during the trial and during their closing argument, and I suspect again, when they give their rebuttal argument, and I can't get up again and say anything, is going to show you that wheel rim. And that wheel rim has a couple of drops of blood on it. And if you look at the grass, there's blood on the grass. But as Dr. Cook pointed out to you, the blood on the grass is nowhere near what it is inside the car. Because that's where the injury to the part of the body with all the veins, the vascular scalp, with everything running through it, where it can spurt while the heart is pumping. That's where the majority of the blood is, not outside. And when they fell down, you heard even Mr. Stalkey tell you that he couldn't tell whether the spots on the rim were an impact spot or whether it was a castaway, as in someone falling down and blood that they had on them casting onto that. He began pumping her to save her life. I'm reminded by the state's approach to this of the parable of the blind men and the elephant. It's an old parable. Nobody's sure whether it originated in India or Burma or Thailand. But a group of blind men heard that a strange animal had been brought to town, an elephant. And none of them were aware of its shape and form. And so they thought they would all go and touch the elephant to try to see what an elephant was. And when they found it, they groped it. And the first one put his hand on the trunk. And he said, "This elephant is a big snake." And another went to its ear, and he said, this creature is like a fan. Another touched its body. Said, no, it's like a wall. And another touched its leg and said, no, it's like a pillar. The one who felt his tail thought it was a rope, and the one who felt its tusk said, no, it's really like a spear. And the parable teaches that subjective experience can be true. but it's inherently limited by its failure to account for other truths, for the whole package, for the totality of the truth. The investigation into what occurred here was an interdisciplinary problem. It involved pathology, it involves medicine, and specifically trauma medicine, it involves biomechanics, it involves glass, it involves DNA, it involves blood, and the state never approached it that way. The state approached it with tunnel vision. It was like the news media on this case. During jury selection process, we took a long time with any of you who had read anything about this case, because we had to make sure that your minds were open, that you had developed already an opinion about the case, that you would listen to the evidence objectively, because in order to reach the appropriate conclusion, one must be objective. Within minutes of police arriving at the scene, you overheard in one of the tapes of after talking to Todd Kent Hammer, Officer Leffelholtz turned to the other officer and say, "Is this normal?" And people begin to question him that day when he is terribly distressed. 3 officers questioned him that day. 3 officers questioned him that day, and over 50 times during the questioning, over 50 times, all he says is, "How is she? Can I see her?"
Welcome back to Law and Crime. I'm Caroline Polisi. I'm here with you this afternoon. And as I said, we've been doing lots of special segments for you today because there's lots of legal news going on here. Today, we're fortunate to talk with our special guest, Saam Zangeneh, about the Me Too movement, which is reaching the upper echelons of our judicial system at this point. Specifically, there is a sexual harassment probe now being launched in the case of Ninth Circuit Court of Appeals Judge Alex Kaczynski, who has served on that court since 1985. Now, Saam, I have to say that this news was shocking, but not surprising, because obviously, we're seeing a lot of high-powered men they're dropping like flies, really, is what's happening. And it's not just the media, it's in all really sectors of professional life. And one would assume that that would include the judiciary.
I mean, it's a tough pill to swallow that this is happening, but like you said, what do you think men in power do sometimes? They abuse it.
Right.
And that abuse runs from Hollywood directors to actors to politicians to people with influence. And so, was I shocked to hear that a judge was unbelievably inappropriate, borderline criminal with his staff and other young attorneys? No.
Yeah.
It's outrageous, to be honest with you, that this was, what they were saying was going on,
right.
Just making somebody watch pornography with him.
Yeah, and I want to get into that. I want to get into that for our viewers, because many of our viewers might not yet know now. But Chief Judge Sidney Thomas in the Ninth Circuit has announced late last night, actually, that the Ninth Circuit's Judicial Council has brought a complaint against Kaczynski, and it's been determined that a separate federal court, I think perhaps the Third Circuit, will conduct that investigation and take discipline action if necessary. The latest breaking news is that apparently up to 3 of his current clerks have resigned. He's a renowned feeder judge, meaning that he sends clerks off to clerk for the Supreme Court. And this complaint is based on allegations that came out in that bombshell December 8th article by the Washington Post, in which the judge was accused of sexual impropriety with at least 6 women who had worked with him over the years. And I noticed you said, what I think is interesting, what you said borderline criminal. I think it's that borderline issue that society is now grappling with, because, at this point, there are no sort of physical allegations alleged against him. This isn't, an alleged rape or an alleged sexual assault. It's just highly inappropriate behavior being alleged that this judge perpetrated throughout his tenure with his clerks, and specifically one of the blog posts, one of his former clerks, Heidi Bond. I don't know, did you read her blog post?
No, I haven't read that.
So it went viral. She went on the record with the post. She alleged in a detailed blog post sort of the torture she endured throughout this year that she was Judge Kaczynski's clerk. And, it started off with him making a joke upon her swearing in that, there was no turning back now, that she was now his slave. He'd use the word slave. She sort of made a joke at the time, I think you mean indentured servant, ha ha ha, and he said, no, I mean slave. At other points, she alleged that he, told her that she would have to take orders from him about when she would sleep, when she could eat, when she could do certain things. He censored the reading materials that she could read on her dinner break. I mean, the level of control that he exerted on his clerks was out of control. And she remembers at least 3 instances in which she was called to his chambers alone to look at pornographic material. She was asked whether or not it turned her on or whether or not it aroused her. And, she describes in horrifying detail sort of her interior monologue taking place over the course of this harassment, really. And one of the unique things about this situation is that clerks take a confidentiality oath to maintain the confidentiality of judiciary proceedings. They're not allowed to reveal, not just during the time of their employment, but throughout their lifetime, what occurs in judges' chambers relating to making decisions. Now, a lot has been said about sort of the judicial ethics of that and whether or not a clerk can speak out if they feel that it is outside the scope of a judge's sort of inquiry into making a decision. What do you think about this institution specifically, about sort of the relationship between a clerk and a judge, and whether or not that really should be setting off alarm bells for society right now?
Well, let me tell you, federal judges, once you become appointed a federal judge, lifetime appointment, that's it, you're bulletproof. So you can pretty much do whatever you want as long as you don't do what this judge did, and you can have a job, a very well-paying job, a highly respected job. You're in the upper echelon in terms of the hierarchy of the judiciary in the United States, and so there comes a lot of power with that. And I think initially when the formation of these clerkships occurred, they wanted to keep the inner monologue or how things are determined. They wanted to have a level of privacy and decorum because that was part and parcel of how things were done. But look what's going on now. People are taking advantage of that, I don't want to call it loophole, but that situation that allows judges to act freely without any recourse because people are, in essence, bound to secrecy.
Yeah.
And so we need to make a change. There has to be a change that's made because, look, what's going to happen to this guy? What can they do? They can impeach.
Yeah.
Right?
Yeah.
What else can they do? That's it. And to impeach him, it's going to take years to impeach him. It's not something that happens. It's not like someone walks into an office and goes, like Donald Trump, you're fired. No, there's a total protocol that goes. I mean, it's in essence a legal proceeding.
Yes.
And so that's it's just we have to figure out a better way to remove people from the bench if they're doing something inappropriate. And let me tell you, from what these people were saying and the detail in which these women were able to resuscitate what happened,
yeah,
they come across super credible.
Yeah.
And listen, and so what it shows is that this judge, everyone deemed him to be like a pervert, like dressing women down with his eyes, touching people potentially a little bit inappropriately, making unbelievably inappropriate comments. And so he had that stigma. So knowing this should have been this should have come up a long time ago.
Yeah.
I'm shocked that it didn't, but I'm glad that it came up now, because people like that don't deserve to have that position.
It's a good point. Dahlia Lithwick at Slate, who I've admired throughout the course of her career, recently came out with an article
I read it.
backing up the claims. She was never a clerk for him, but she interacted with him. She was friends with some of his clerks, and she, again, the allegations against him, they're not criminal, as you said, they're just creepy. She maintains that, and it was kind of an open secret, again, that he would undress her with his eyes. He once called her at her hotel room and asked her what she was wearing. I mean, things like that are just completely inappropriate. But and also to your point about sort of how the institution is shrouded in secrecy due to sort of the unique nature of the judiciary in and of itself. Chief Judge Sidney Thomas, in his announcement that the Ninth Circuit's Judicial Council was going to bring this complaint and was going to look into this issue, he broke protocol on that, and he said he did so in the spirit of transparency so that the integrity of the judiciary could be upheld in the public's eyes. Because since this story came out in the Post, I mean, this is not doing any favors for the federal judiciary. So I think that was a smart move on Justice Sidney Thomas's part, to raise this issue in the public eye and say that from here forward, any allegations that come forth at this point on will be kept, kept secret. However, the fact that this inquiry is being done and that disciplinary action may take place is we're letting that out in the public sector so that society knows we're taking this seriously.
Right, listen, there's got to be like an HR department,
Yes.
where you go
Like in the
in and you go,
Senate.
listen, this is wrong. And let me tell you what I think a lot of people are concerned about is that from a political standpoint, that if something does happen to this judge, who has, even though he's Republican, he's got some, he does have some liberal tendencies.
Ronald Reagan appointee, by the way.
I'm sorry?
Ronald Reagan appointee in 1985.
Correct. Reagan appointed him as a Republican. But I got to tell you, smart guy, some really good decisions. I've read some of them. He's not a far-right person. He can be moderate at times and maybe dip on the left side a little bit. And so listen, think about it. What happens if he resigns or gets impeached? Then Trump gets to appoint another person to the federal bench. And look what's going on now with the appointees that Trump has put up, these young guys that have no experience. I saw somewhere where there was, I think it was Senator Kennedy was inquiring one of the prospective judges. He didn't know what a motion to eliminate was.
He didn't know what a Daubert standard was. He didn't know what a motion to eliminate was. He hadn't read the federal rules of evidence since law school, I believe.
No, let me tell you, he's never read the rules of evidence. And so, so it's more of a global, like, what's going to happen next? Because clearly what this judge did, gross, wrong, and should not be something that occurs. And we have to fix that system. We have to have a situation where if somebody on the federal bench is acting inappropriately, that you are able to do something about it, to either put him on notice, hey, listen, this is what's going on, change your behavior,
right,
or to remove him.
Right. It's kind of like a similar issue that the Senate is dealing with. As you sort of joke, they need a PR department, but the fact is there needs to be some sort of system in place, whether it's an ombudsman, whether it's sort of a PR or sort of a...
I agree 100%.
There needs to be a procedure in place because, again, Ms. Bond, throughout the detailing of her really anguishing year, she went to several people who couldn't give her good advice. It was actually finally when this Judge Kaczynski emailed her years later about Heidi Bond went on to clerk for the Supreme Court. Which was typical for many of these Kaczynski clerks. Again, he was a feeder judge. It was highly prestigious, a plum job. It was considered, you've won the legal lottery if you get to clerk for this guy because you're going on to the Supreme Court, and who knows where your legal career is going from there. So she discusses about how she thought about walking away from this position mid-year, halfway through the year. She was really experiencing symptoms of PTSD. She would wake up in the middle of the night in a cold sweat, fearful of what may happen the next time she was called to his chambers alone.
Think about this. How crazy is what you're saying?
Yeah.
That's not okay. That's not okay, and it's such a ridiculous situation, and this is going to infect our judiciary. Think about this now. This judge is going to be on the bench. How many people are going to file motions to recuse him?
Right.
I mean, how can he be fair and impartial if there's ever an issue of you don't know what this man has done, you don't know what relationships he's burned, and if he has that kind of like dilatory position where he just completely crosses the line and is inappropriate, does he allow certain factors to influence him when he's making legitimate legal decisions?
Right, and which he has, by the way. He's made legitimate legal decisions about sexual harassment specifically, and I have some quotes from him. But one of them is that, and I'm paraphrasing here, men need to be more sensitive towards what could be offensive to women. But which I thought was interesting, he specifically said that women also need to sort of cut men a little slack in that they may find something humorous that a woman may not find humorous. So again, Monday morning quarterbacking, it's again, we can look at Matt Lauer's interviews, prior to this news breaking, and we can read sort of nefarious things into there. You can do that with his opinions as well. But it's interesting to look back over his work over the years. I agree with you, he's not super conservative. Certainly he's and Heidi Bond made that point. She said specifically in this blog post, she said, don't ask me what to do from here. I'm making my allegations. I believe that he's a genius legal mind, that he's a fabulous judge. I don't want any part of this discussion. I don't want to be a part of this discussion. I just am here to tell you what happened to me, what I experienced, and let's let sort of the judiciary as a whole determine what to do with him from here on out.
But listen, think about what she just said. She's like, listen, I don't want to be involved, but I'm involved.
No, but she's saying she doesn't want to be involved in what happens to him after this point. She has no sort of political, skin in this game. You're going to hold her. You hold her accountable for you think that's disingenuous on her part?
Well, listen, I think that if somebody wants to be involved and somebody wants to make an allegation like this, you're in for a penny, you're in for a pound. You have to be able to realize that once you make this allegation, these are serious allegations, because a lot of people are gonna, how can I say this? People are often gonna question the veracity of victims. Okay, like look at Roy Moore. Look at the former Senator Roy Moore. And there were some really horrific and criminal allegations that were purported against this guy. And so those people, they're going to have to go from the beginning to the end, because once you make this allegation, because this is not, as defense attorneys we know, imagine if a 12-year-old girl accused me of touching her. What happens to my life? It's over. I'm going to get arrested. I'm going to lose my bar license. I'm probably going to get divorced. I'm going to spend all my money on my legal team to defend against these allegations, because these allegations are life-altering allegations.
Yeah.
So it's not that I don't think that she's being disingenuous. It's just, it's a very hard situation for people to want to understand that they're going to have to, she's going to be involved in this, and she's going to have to be prepared to maybe be involved in an impeachment. Because
But not of her own volition. I mean, this is something that happened to her. She didn't choose to be involved in it at the time. She didn't choose to be asked into this man's chambers and look at pornography. She didn't choose any of that. So I got to disagree with you on that front.
What happens if he says she did? What happens if he says, you know what? She's right, but she wanted it. She's the one that was flirting with me. She's the one that maybe shared a situation, or we had a conversation, or she made a direct reference to something sexual, or we were having sex. Who knows what he's going to say? I don't know what he's going to say, but she's got to be prepared, just like Todd Kent Hammer, to be cross-examined by someone on his side.
Yes.
Because ultimately, this isn't going to go away.
I agree with you. I'm a defense attorney too. Due process can't get lost, sort of, in this moment. It's an important factor. We're going to have to stop the conversation there, Saam, but thank you so much for being with us today, talking about these important issues.
Thank you so much for having me.
We appreciate your insights, and we hope you'll come back to join us.
Absolutely, we'll do.
Thank you, Saam. So we are getting ready for some more special segments. Later today, I'm going to be discussing that issue that Saam alluded to here with Aaron Keller. He's going to talk about some recent articles that he's published on lawandcrime.com, so you can preview those articles there. And until that time, we're going to play back replay of the Todd Kent Hammer closing statement.
Will she be okay